All right. The Honorable Justices of the Supreme Court. Court from recess, now sitting.
Please be seated. Return to a much emptier courtroom. All of you need to get your home high schools to start attending your argument. So we have a group, but we welcome those of you who are here. So with that, I would ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the 10:30-ish, 11:10-ish docket, please.
First case on the 10:30 a.m. docket for Wednesday, March 27th, 2024 is appeal number 124611, State of Kansas versus David W. Moeller, Jefferson County, briefs both sides.
Morning, Your Honor. My name is Randall Hodgkinson. I'm here today on behalf of David Moeller. I would request 3 minutes for rebuttal, please.
3 minutes is granted. Thank you.
Your Honor.
May it please the court, Chris Asleger appearing for the state, present and ready for argument.
Second case is appeal number 125455, State of Kansas versus Matthew Munoz, McPherson County, briefs both sides.
May it please the court, Patrick Dunn, Deputy Appellate Defender, here today on behalf of Matthew Munoz. We're ready for argument, and I would ask for 3 minutes of rebuttal, please.
Granted. Thank you.
Morning, may it please the court. The state appears by Stephen Obermeyer, an Assistant Solicitor General, present and ready for argument.
Your Honor, that concludes our 10:30 docket.
Thank you, Mr. Shima. Now ask the attorneys in 124611, State of Kansas versus David Moeller, to please come forward.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of David Moeller. And I would like to pause right at the beginning to say I am representing David Moeller. And notwithstanding the district court and the Court of Appeals finding that Mr. Moeller is deceased, I still understand that I have legal and ethical obligations to represent Mr. Moeller. That's what I've done through this proceeding. That's what I'm doing today. It's my understanding of my responsibilities.
And do you have that authority? I guess that my question is, we view this as an agency relationship, which typically agency relationships terminate upon death. And I think we have some case law that suggests that. And to me, maybe that's the biggest hang up with the Hollister approach, is that who then has authority to push this thing forward?
So I'm certainly still subject to a court order, I believe. I mean, my office was appointed to represent
I'm not
Mr.
suggesting,
Moeller.
I'm not questioning yours. I'm just more your continued representation. I'm
Yeah.
just more theoretically, from a legal perspective, under our abatement doctrine, it seems like absent a procedure to substitution, there's nobody left here to carry the bag, so to speak.
So I guess my answer is twofold, Justice Wall. One is, I'm still subject to a court order. And so, that's where I believe I have legal obligations continuing. And yes, and in fact, it's interesting to me, and as I brought up in my supplemental briefing here, the idea of there could be the possibility of some sort of substitution. That's what the Hawaii Supreme Court's done. That's what the Ohio Supreme Court has done. And in those situations, for example, then those courts have said, we'll find somebody, and it could be the defense attorney. And when I sort of read those, I thought, oh, you know what? That's what we used to do before Hollister, effectively, as a practical matter. And in fact, it's what we still do under Hollister effectively, that even if there is a finding that a client of ours has died, that we continue to represent them until we are told we don't have a case any longer. That could change if this court adopted abatement ad initio. That might change those things. Or if there was substitution, and for the reasons I set out in my supplemental brief, I think that is an option for the court, because there are Kansas laws that provide for substitution of parties in court cases. And generally speaking, those rules of civil procedure apply on appeals, and in fact, apply in criminal appeals unless there's something. So to me, it was sort of interesting as I was sort of getting ready for supplemental briefing, is because I thought for a long time that the effect of substitution is an elegant solution here, as opposed to sort of the categorical, it's all or nothing approaches of abatement, ab initio, or non-abatement, pre-Hollister. The idea of sort of having more of a case-by-case approach to this, to say, state, do you feel like this is a conviction that we need to have still in existence? And if the state says yes, then you go, okay, then we should have an appeal of it and find out whether it was lawfully entered.
I inferred that you had an objection to filing a suggestion of death on the record, which generally in civil cases is what triggers the substitution process. I didn't understand that. I didn't think. Can you enlighten me?
Sure, and Your Honor, I'll say this, by the way, is tailoring into, because I understand I'm asking this court to revisit Hollister. And in order to do that, I have to explain why Hollister is bad. And this is in fact part of that. It's because I feel like it puts me into an adverse position with my client if I sort of have these obligations to bring up adverse facts as it relates to my client's appeal. So under Hollister, as I understand it, now, and this is what crystallized for me a little bit, even just during this preparation, is that the fact of a client's death now becomes adverse to their appeal. That wasn't true before Hollister.
But it could also mean that if there is nullification ab initio, would be very, very good for your client.
That's right. If this court adopted abatement ab initio or even substitution, then it's not an adverse. It could only be good for my client in that it could result in the vacatur of the conviction. But under Hollister, it becomes an adverse fact to my client. My colleague has, in his supplemental brief, sort of talked about, it's just death. That's just a fact. It's just a fact. Like it's not something else. And I tend to agree, it's a fact. It's just that under Hollister, it becomes an adverse fact to my client's appeal. And I use the example in my supplemental brief of Rayburn, where I came to this court and unsuccessfully urged this court to abandon the forfeiture by wrong of the fugitive disentitlement rule. But this court understood that, well, the burden is still on the state. If the fugitive disentitlement rule is going to apply, the burden is on the state to show that the factual circumstances apply that would cause that to be implemented. And but under the Court of Appeals and the state's proceeding here, the state could file a copy of Casper saying, looks like this guy's a fugitive, and this court has said, well, that's not evidence. But the Court of Appeals could say, well, counsel, we want you to investigate this and determine whether or not your client is a fugitive and report that back to us.
That strikes me as an issue with the Court of Appeals order, not Hollister. I mean, Hollister doesn't mandate that process. So in terms of a stare decisis analysis, I'm not so sure how that weighs into that.
If the Court of Appeals, and you clearly said the Court of Appeals is wrong in the way it's proceeding in these cases, then that might be right, Your Honor, that would be less persuasive as far as the stare decisis.
And then under the Rule 1.16, it looks like comment 23 kind of walks counsel through what you do. You have two options. You can assert privilege, litigate it, and then if the ruling is adverse, you can then appeal from that order, or you can then disclose the information that you were challenging. And I don't believe you asserted privilege in response to the order, did you?
In response to the order, no. I mean, I argued that it wasn't my burden of proof. And so, and I mean, I think that's wrapped up in that, Your Honor, the idea that it's not my job, or really not even an appropriate question for the Court of Appeals. The underlying basis of that, in part, not in total, but in part, is based on confidentiality. The second part of it, I'll come back then, Justice Wall, because, I mean, if you agreed with me that, you know, the Hollister, the way the Court of Appeals is applying Hollister is incorrect as far as the burden of proof, I would still argue that this court should revisit Hollister. This court recently, as recently as wrote in 2020, said that the mootness doctrine is a prudential doctrine based on saving judicial resources and on appeal. And I would note to you that Hollister actually does the exact opposite. For example, let's use this hypothetical. I've been appointed on a case, very typical. I've docketed the case, and then I get some information that my client may have passed away. What do I do? Well, again, assuming Hollister, that the way the Court of Appeal, you know, I'm not gonna do anything. I'm gonna still have to get transcripts and pay for them. I'm still gonna write a brief with all the issues. Here's the only possible difference is I'm gonna be sure I raise a sufficiency issue now, because Hollister says that may be the only thing that causes my client to have their appeal survive. So maybe I file a sufficiency issue that I wouldn't have otherwise, but I'm going to file the same brief. And the state's going to have to file a response brief, because at that stage, we don't even know what the issues are in the case. It's not going to stop that process. It's still causing us to expend all of the resources from the attorney standpoint on the front end for a case that, as we see in Cada, as we see in Baker, then just gets dismissed. We never get a resolution of the issues raised in that case. That's wasteful. That's wasteful.
I
And
understand. Go ahead.
Sorry. Your hypothetical just sort of, I mean, it is an interesting circumstance, and appellate work is a unique kind of lawyering. So I understand all of that, but even just the way you framed the hypothetical just strikes me that it raises the obvious question of, shouldn't a lawyer know whether his client is alive or not? And doesn't the lawyer-client relationship sort of demand that you know that? And your entire hypothetical is based on the fact that appellate lawyers have no idea whether their clients are alive or not.
I wouldn't go that far, Your Honor. So first of all, I'm appointed. So even the Court of Appeals recognized that it's not necessarily the case that I always know where my client is or what the status of my client is. And
I was trying to recognize that with my comment about the uniqueness of your role, but just as a baseline assumption, doesn't that seem faulty to the attorney-client relationship?
that I might not know whether my client is alive or dead?
Right.
No, I mean, I'm appointed by the court to represent a person. There are any number of circumstances where I may not know if my client is alive or not. And in fact,
It just seems odd to me, I guess. Maybe it's correct.
Yeah, and maybe it's a distinction between, and it kind of goes back to Justice Wall's question of, I mean, is there a difference if I'm retained, right? And I'm an attorney by contract, you know, and that might be different, but I'm not. I'm appointed by the court. And so, so the answer is no. And it's, now, am I interested in that question? Yeah. If I get information that my client might be deceased, am I doing something about that to check? As a lawyer, do I think I have an obligation to do that? Yes. That's different than, do I have to disclose adverse facts and things like that?
Along with the way you've answered my questions, it would follow that your position is that you have, as an appointed attorney, you have no obligation to attempt to talk to your client.
No, that's not correct. I understand that as an attorney, I have continuing duties of, for example, communication. That's a duty every lawyer has with their client. And so I always have a duty to try to contact and be in communication with my lawyer, with my client. I'm just saying, as appointed counsel, that's not always possible.
Okay.
The Court of Appeals seems to not recognize that.
Practically speaking, what, it seems like maybe we've had a handful of these types of cases since we went to this sort of modified approach. It doesn't strike me that it's been difficult to administer, or, you know, the more good than harm sort of argument in the stare decisis analysis. What's your pitch there?
Yeah, so it depends on where, from my standpoint, it's been very difficult. And I've now had, you know, I should clarify the Court of Appeals. I don't know if they were kindly or, you know, talking about you know, this is a recurrent issue with the Kansas Appellate Defender Office. No, they're citing my cases, right? It's not, I don't get to speak on behalf of the Kansas Appellate Defender Office. I'm not today. So I disagree with that. And certainly this waste of resources is true. And it's less important, ironically, but it's also leaving illegal judgments in place, illegally obtained judgments. And that's a harm that's associated with the Hollister, as opposed to if this court adopted abatement ab initio or substitution, all of these problems would be solved. All of them would be solved because either the conviction goes away, my client's happy, I'm done. I could get rid of that case at docketing, or we have the appeal and we decide whether or not it's a valid conviction.
What happens, sorry. What happens to restitution ab initio?
It would go away. Restitution in a criminal case, if it's criminal restitution, there has to be a valid judgment on which that restitution judgment is based. If it goes away ab initio, the restitution judgment goes away. And that's, at that point, we don't have to worry about were there any instructional errors, were there any evidentiary errors.
But what I'm saying is, doesn't that do harm to a victim? Because wouldn't it be, if there was a restitution in place, wouldn't the state have to pay for it?
Would the state have to pay? I'm not sure what you mean by the state.
The estate.
The estate. Maybe if the victim, files a civil suit or something like that. But that's, and by the way, I would respectfully, in my opinion, respectfully, I think Hollister is conflating the issue of mootness with the issue of remedy. And I think that goes to some extent to your question, Justice Standridge, that what happens after this court would do what it always does in every other appeal. That's a separate issue, right? That doesn't have to do with mootness. Here's the thing. It seems to me that the underlying conviction is moot or it's not moot. If the underlying conviction is not moot, then the appeal's not moot because this court can do something about that conviction. It can reverse it. If that underlying conviction is moot, then I don't understand why abatement ab initio isn't the right approach. It would save judicial resources. It would correct all these problems, get these cases out at the earliest point. Oddly, my colleague and I seem to agree that these convictions aren't moot. That seems to be my colleague's position on this, maybe because of restitution, maybe because of the emotional impact of these convictions. If that's true, that's fine, but then we should have the appeal like every other case.
But how do you get over the procedural hurdle? I think I can agree with you there, but it's like, in a civil matter, you do, as Justice Wall says, you can substitute a party. Who wants to substitute for a defendant?
I
how
can't.
did that happen?
That for me, that was the news when I read the Hawaii and Ohio. The Kansas Appellate Defender Office can if it's an appointed case,
But then.
which is in effect what we did before Hollister.
What do you do about remedy then? Because the Kansas Appellate Defender Office doesn't want to be responsible for the restitution and costs.
Yeah, as I understand, go ahead, Aaron.
And if you do get to that stage, we are talking about a substitution. Because for the state to go back against the estate, there's going to have to be an estate. So I agree with you that there seems to be a line that we should perhaps be drawing when we think about conviction separately from the remedy in that regard. But how would we deal with that?
So, I think when we talk about substitution, it's just, as I understand it, under the Hawaii and Ohio Supreme Court decisions, it's who gets to make decisions. It's not like the Kansas Appellate Defender Office becomes liable for restitution or that I might go to prison or that's not what, it's just who is the person that makes the decisions in this case now. And what was interesting to me was it might be next of kin, but it could be the appointed attorney.
But actually, in the civil context, it's the question of who's the real party in interest in terms of liability. And that's why substitution usually is maybe by a personal representative, but if essentially the estate.
But in a criminal context, I don't know that I think that's what the Hawaii and Ohio Supreme Court are saying is it's really just the decision-making part of this. And that in those cases, again, that's because I practiced a long time and I practiced a long time before Hollis. And I had cases where clients died. And it turns out, nothing's different. I know exactly what to do. I know exactly what my client wanted.
But it is that substantive difference that makes me concerned that the civil procedure doesn't really apply. It's not a perfect fit here.
You know your code better than I'm going to talk to you about civil procedure code. But to the extent that that's true, again, and I sort of made this in a footnote in my supplemental brief, this court could adopt a new procedure. I mean, this court has the inherent power under its own constitutional authority to make rules of appellate procedure. So to the extent that this, you would think it's different, but you like substitution, you just don't think it fits within the civil rules, this court could pass a rule affecting it. There's nothing stopping you.
And that would be through our ordinary rulemaking processes with notice and public input and comment, not judicial opinion.
Well, I guess, I mean, you make rules through judicial opinions like Hollister and cases like that, so. Your Honor, I'm over my time. I keep talking, but thank you.
May it please the court, Chris Elslager appearing on behalf of the state. The state's position is that Hollister strikes the right balance between the competing interests of the state and the defendant. It maintains an opportunity for the defendant to try to clear his name, but at the same time allows for the state to pursue its interest in getting issues of statewide importance clarified and ensuring that a valid conviction remains on the books and that the victims have proper closure for their injuries and that restitution remains in place. And that's essentially my argument. The issue of substitution, well, I will tell you, it seems like another reasonable alternative. I think though it's not necessarily, I don't know that it has any advantages over Hollister other than because it would keep the same interest in place, but it would also allow for truly moot issues to be brought to the court, which I'm not sure that there's any reason for that.
Piggybacking on Justice Wall's real party and interest comment.
Say that again?
I'm trying to piggyback on Justice Wall's comment about the real party and interest. In other words, that being the conceptual idea behind civil substitution is who's the real party and interest. Does that carry over into criminal law? In other words, I find the whole notion of substitution in criminal law to not work for the reason your opposing counsel pointed out, which is, look, I may be substituted, but I'm not going to prison.
Well, first off, I don't think I'm as smart as you think I am. Let me think about that a moment. Yeah, I mean, it doesn't carry over exactly. I think it's.
I'll just put it bluntly. How can someone substitute themselves in a criminal case without putting themselves at jeopardy of going to prison?
Well, keep in mind, I'm not advocating for substitution. I'm just saying, I listened to his argument. I don't think it's a necessarily unreasonable one, but.
I mean, the reason I started asking my questions is because you said, what I heard you say at least is substitution seems reasonable to you.
Yeah, I mean, if there's some way to do it, I mean, and I don't know who you would put in there, maybe the estate. I don't know. What the state doesn't want.
The point is criminal liability is so intimately connected with the person.
Right.
It is not something that can be easily divorced from the person and placed onto some other party, like various civil obligations.
I agree. And I think you'd have to look back at the reasoning of the Hawaii courts and the other courts that adopted substitution. But and I think maybe they had some kind of actual statutory procedure or something for that. I don't recall those cases. I'm telling you, I'm not advocating for it. I think the Hollister decision is fine. The state's okay with that. And as I made clear, I think in the supplemental brief, what the state doesn't like is the idea of abatement, because that washes away a valid criminal conviction for no reason other than an accident of fate.
But it doesn't find them innocent.
I'm sorry.
It doesn't find them innocent.
Well, I think it just
Because
simply
they're-
vacates.
Your journey isn't over yet. We don't find them innocent even if we reverse, they're in a situation where they have to try it again and they may lose again.
Right, but the abatement just vacates, my understanding of abatement is it vacates
Vacates the
The
conviction
conviction.
and drops the charges.
Right. which,
But it doesn't find them innocent.
The reality is there still is a free finding. I mean, I understand, I understand that, wanting that process for the victim, but the process has happened. There was a jury verdict. it's really a technicality. And we talk about technicalities all the time, but there still was that finding.
But why not just leave it
So
in
what
place?
more?
I mean, I don't understand. I honestly don't understand why we would abate it if there's been a finding beyond a reasonable doubt. But the bigger concern, I think, really, the real practical concern is the restitution order. Like in this case, you know, this victim was ripped off about $10,000. And, you know, I don't know if there's money in the estate. I know, you know, I don't know anything beyond that, but let's just assume that there is money in the estate that could pay that restitution. If the restitution order goes away, then yeah, sure, the victim, I guess, could pursue a civil suit, but that's hiring a lawyer and going through the whole process again when there's already a valid restitution order in place.
Well, they could
But you have
just,
to have due process. I mean, I know I'm asking questions out of both sides of my mouth, of course, but you do have to have due process before you can get to that stage of enforcing a judgment. There has to have had that process. And why, and who is left for the payment of that restitution? Unless you do the substitution and that gets back into that loop of who do you substitute? Frankly, it just seems like there are hurdles at every stage of, I'm not sure there is I think the word that Hoskinson used, an elegant solution. I don't think there is an elegant solution to this problem.
Oh, I would agree with that. That's why I think Hollister just kind of struck the right balance for a difficult situation, because it does allow each side to still pursue those interests that are still alive. Like if the
And what
defendant
is-
wants to clear his name, he has that option. If the state believes there's some, you know, issue of statewide importance or real controversy, or perhaps the restitution order the state wants that to remain in place, Hollister gives us that option. I think.
What is the purpose of the restitution order, since it is now no longer a civil judgment?
Well, it's again to repair the damage to the victim done by the defendant's criminal act,
No defendant left to pay.
but he still may have assets or you know, whatever.
You have to open an estate to get to that. You can't make a claim against a decedent without an estate, can you?
Okay, I will admit that
Under Hollister, let's just take that hypothetical, if it is litigated and you have a final judgment under a Hollister type appeal, at least that has preclusive effect in terms of liability, would it not? Even if the victims wanted to bring a civil suit against the estate.
yes, I'd agree with that. If I understand what you're saying, and I have to admit, I don't do civil practice. I don't do estates. I learned that stuff in law school, but that was like 25 years ago. So the mechanics of that are a little bit over my head at this point. If there is a process though for that to happen, I think having the opportunity to keep the conviction in place and that restitution order in place, I think is important, even if the victim has to then go to civil court and say, hey, I want my restitution. At least you've got that order from the criminal case that shows the liability. I think that would at least, again, vindicate the victim's rights, because
Can it, when we're only looking at sufficiency on appeal under Hollister? If a defendant has raised 8 issues, one of which is a sufficiency, and under Hollister, we're going to look at the sufficiency. We're going to look for actual innocence. But that doesn't mean that there was a valid jury verdict. There may have been errors that would lead a court to have overcome, reversed that jury verdict. So I really do question that judgment does have preclusive effect. If there are legal issues that are unresolved that attack the verdict.
Well, I mean, the other option, of course, is, and I think my colleague would agree, we could just just allow the appeal to continue even past the death of the defendant, to let those issues.
What happens
But-
if one of those issues warrants a remand?
Well,
For
then
retrial.
therein lies the problem, because then it really is a moot issue, because there can't be a retrial because the defendant is dead. And this is the problem. I mean, that we're wrestling with this. Why, like I said, I think Hollister just kind of struck a balance. It's not perfect. It's not elegant, to use Randall's phrase there, but I'm not sure that there's not any solution to this that really would make everyone happy. I think Hollister kind of, splits the baby in a way that we can all sort of agree with.
Well, one other option we haven't really talked much about is is the other side of the balance, which is why isn't the whole thing moot?
Well, again, as I pointed out, I mean, the state has interests in ensuring that, you know, a jury verdict stands and that the victims get
Well, I'm not talking about
proper vindication for their
void. I'm
injuries.
talking about just that it's moot. I mean, I understand that you object to the
Well,
remedy of voiding the whole thing.
I mean, if you declare it moot, but just don't, but leave the conviction in place, I'm fine with that. I think that the state's fine with that.
That is my question.
Yeah, I mean, I think that also is the only option that the state is really opposed to is just complete abatement. If you just rule the case as moot and the conviction and
I mean,
restitution
let me give
stays
you
in
another
place.
hypothetical. I don't know. I presume this probably has happened from time to time, but you proceed to trial on a first-degree murder charge, let's say. You get a guilty verdict. The court sets a sentencing hearing a month later, and between the verdict and the sentencing, the defendant dies. What happens?
I don't know. Obviously you can't sentence him because he's
Right.
dead.
I mean, it just moots the whole thing. I mean,
Yeah.
doesn't it? But the conviction is still there.
I suppose in that unique circumstance, that would be,
How is this any different?
well, in this case,
I mean,
we've
I
gone,
guess that I
we-
get that it's
we've gone through
procedural.
that first phase. That first phase is done. You have the valid.
Conceptually, is there any difference?
Well, I think conceptually there is because we've got through those procedural steps. There is a valid sentence in place. There is a valid conviction in place, and we're on appeal.
But
I mean, how's it?
isn't that a presumption though? That the conviction was valid? I mean, what if it was a complete sham? That, not that I would never suggest that that happened in this case, but what if it happened? That they planted evidence and it was, witnesses lied and it was a complete sham of a conviction. And that is appealed. Where's the justice there if we just leave that in place with
Well-
horrible errors?
And that's why I think ultimately the Hollister decision strikes the right balance, because in that kind of situation, the defendant would have the opportunity to vindicate his rights, even though he's passed away, and point that all out. I do want to, if I can, return back to here. I mean, the other way, I mean, we do look at this differently too. Let's say we've got through the appeal process and they file a 1507 and they die. Well, we don't go all the way back and vacate. So there is some meaning to the procedural steps being crossed, I guess is my only answer to that. Although I admit conceptually that's a difficult hypothetical for me. I get that. And again, I don't think there is a nice, elegant answer. I think, the court struck the right balance with Hollister, and I don't think my opposing counsel here has given the court a real compelling, persuasive reason to just abandon Hollister. Hollister so far has worked for what it can do. And the state would ask the court to just go ahead and affirm Hollister. There's no reason to go down another path and try another, maybe another dead end. I don't know. I just think we've got a system in place. The court obviously reasoned it through in Hollister, and I would just ask the court to affirm it.
Yeah, but this was argued in, Hollister was 2014. And this seems almost like a deja vu to that argument. It's how do you strike a balance between the defendant's appellant's interest in exoneration versus yours and accountability to save? And the part that I didn't, well, I shouldn't say we didn't, but the Mr. Hodgkinson's issue with who makes the decisions in the case. What's your thinking about that? He has a client that's dead. He's acting as an advocate, but ultimately, isn't it the client that makes the decisions on how to proceed?
Well, I think in theory, yes, although as I think Mr. Hodgkinson kind of pointed out in his argument, that when it comes to appellate practice, the clients, I don't think are particularly involved most of the time. But yeah, I mean, if we're going to look at this purely in theory, yeah, the client should be making the call. And if the client's not there, then the only thing the attorney can do as his advocate is look at, well, what is in the client's best interest as Mr. Hodgson has made clear. And certainly, I think we can all probably agree that, at least intuitively, that anyone who's been convicted of a crime will at least want to try to clear their name. So at least that much would continue, which is what Hollister, I think, was all about, was that the defendant should still have a chance to clear his name. And at the same time, if there are issues of statewide importance, we should have an avenue to get those heard so they don't just, continue to fester.
Should we be thinking about an amendment to Rule 2042 that requires the state to give notice of this as if it was a custodial change?
Well, that opens up a can of worms.
Right now, that's,
Yeah.
right now that rule applies only to sentencing appeals. I think there's strong argument that could be made that that limitation should be, it should just apply to appeals generally. We see a number of cases where, just looking at the sentencing journal entry, it looks like the person has served their convictions, and there are other things that sometimes you go, why do we not have a change of custodial status and we're not seeing it?
Well,
Anyway, your thoughts about adding death to that rule?
well, I think that here's the problem. The problem with the rule as it is, I mean, the state would really appreciate if just the parties were responsible, because here's the thing, we don't know, the DOC doesn't tell us when somebody gets released and like that. We don't have any, sitting in our office or any county attorney's office, the only way we can check to see if somebody is in custody or not, we get on Casper just like anybody does and look and say, oh, it looks like he's still in custody. Okay, let's hope that doesn't change before oral argument, maybe check right before oral argument. Because we don't get any notification. Now, if it looks like he's out, or you look at the journal entry, he should be out, well, then we have to start making phone calls to find somebody who can tell us. And it's like every time I find somebody at DOC who might have the answer, by the next time I call, that person has moved on. I got to find a new person. So it isn't, it's challenging. I mean, it's not an easy thing for us to do. And when it comes to somebody's death, that's even more difficult, because how am I going to know if a person died? Unless, again, he's in custody and I look on Casper and it says he's deceased. Well, okay, I've got an indication there. So, I mean, it seemed like it would be more fair if it was just incumbent on the parties to, as part of their duty of candor to the tribunal, to inform the court if the defendant dies, so that either one of us can do that. And if it's a rule of the court, then that would ease, I think, Mr. Hodgkinson's concern about how he believes that that's adverse to his client. I don't agree with him, but I understand his point of view. But attorneys are required to report things like controlling case law as adverse to their interests. So I mean, I'm not sure how this is. I mean, it's not as easy. It's not an exact analogy, but I mean, attorneys are required to report things to a court and to be candid and honest to a court. So if we're going to have a rule that we have to report that, it would be, I think, beneficial to put it on both parties to if either side gets an indication that the client is, or the defendant has died, to report that to the other side and to the court, so that we're not, we're not playing games and we're not, just because as a practical matter, it just seems kind of like gamesmanship to try to say, well, I can't tell you if my client's dead or not. I mean, come on. He's dead. It's a fact. And the challenge of putting it on the state is it kind of assumes that we know more than we do. It is, in this particular case, it turns out I did find out actually from Randall at some point that this guy might have passed away, but that got lost in cyberspace. And so by the time when this came up on appeal, and I got the show cause order from the Court of Appeals, I had no idea. I mean, I don't know. How am I supposed to know if he's dead? And so I had to go do some digging.
I follow you to a degree if the person isn't in custody, but
right,
they're in state custody.
Right. In this case, he wasn't. I think he was, but you're right. Like I said, I mean, I would just get on Casper and look and say, well, is he deceased? Well, that would give me an indication. But if the guy's on probation or is not in custody, it does become more challenging. So that's why I just say, just put it on both parties. Make us both have follow our duty of candor to the court and tell the court if one side or the other has information. I just don't understand why it's all on why it would all be on the state's responsibility, because we're not clairvoyant either. It seems like if the opposing side has that kind of information, just let us all know. So, I mean, that's my rant on that. I mean, I kind of, not sure I was really prepared for that question. Maybe I should have been, but that's what I can say on that. To circle back around to this issue, again, I'll just reiterate, I think that Hollister struck the right balance. I don't think there's any reason to stray from that. We should just continue to follow Hollister, and I'd ask that you affirm the Court of Appeals if there are no further questions.
Your Honor, I just want to try to answer some of the questions. Justice Rosen, sort of on the question of who makes decisions and things like that. And it's clear the division of authority on an appeal. I mean, the client decides whether or not to appeal. And my client in every one of these cases decided to appeal. They filed a notice of appeal. And under the division of authority, I make all the rest of the decisions in the appeal. That's the division of authority when we deal with appeals in cases. And it's clear, I don't have to do everything my client tells me to do. I have to communicate with my client. I've taken into consideration my client's thing. If I have a client that I can communicate with, but I make those decisions anyway. And so that's why before Hollister, this wasn't even an issue. I mean, if the client died, I know what the client wanted, so it's not an issue. And I know what the client wants today. So that part of it. Justice Stiegel, I mean, I have looked a little bit at your question, and I think the answer is if a client dies between the time of verdict and sentencing, because final judgment in a criminal case is the oral pronouncement of sentencing, and the judge is not able to pronounce judgment. And so the case is dismissed because there is no way to pronounce judgment. You're stuck in that position. So there is no verdict because the only remedy in that situation is that. And that's, again, that's a remedy issue. It doesn't have anything to do with mootness. That's a separate point. Both to Chief Justice and a little bit to this question, I freely admit I don't necessarily understand all the nuances of civil substitution. It seems to me that as Hawaii and Ohio are interpreting it, and this is true. I mean, you can have creditors substituted as a certain party or something like that. That's my understanding from reading these cases is how substitution works. Yeah, let's say I'm wrong about that. Okay, there is still the middle ground, which is, this is again, how we did it before, even before Hollister, is you just have non-abatement, but, and this is in fact what I reached out to Chris to say, look, do you care about this anymore? Does the state care about this particular conviction anymore? Because if you'll agree to make it go away, the appeal can go away, right? I've done everything possible for my client if this conviction goes away. And so maybe it's not substitution, maybe it's some other process.
What does it mean for a conviction to go away?
That it's vacated, that it's no longer a part of the public record, that's not a judgment of the state of Kansas any longer.
Okay, so in your answer to my hypothetical a minute ago, you said the case would be dismissed.
Yes.
And I think I agree with that. Why wouldn't the same apply on appeal? In other words, we can look at a criminal case and there is a line between district court and appellate courts, and the line is a final judgment. But as a whole, we would not say a conviction was quote unquote final until the appellate process had been exhausted. For example, for the start of the time clock for collateral attacks, right? And you would agree with that. So why wouldn't we treat the entire criminal process as one? So I guess I don't conceptually understand the difference between a defendant who dies between conviction and sentencing and a defendant who dies between sentencing and appeal.
No,
I don't understand.
I think I agree with you, Your Honor.
So why wouldn't the outcome just be to dismiss the appeal?
Because it's still leaving the judgment in place.
Well, what does that even mean, though? That's what I don't
There's
understand.
still a district court judgment on the state of Kansas that my client is guilty of this crime.
Wouldn't that be true if the case was dismissed after conviction but prior to sentencing also?
No, that's what vacatur does. It says that's no longer a part of the record and judgment of the state of Kansas.
When you said that the case should be dismissed, you actually meant that the whole thing should be vacated.
Yes. And that's, I think, the right answer. And that's, I think, the dissection of the appeal from the underlying judgment, I think you're exactly, I mean, not trying to put your words in your mouth, but I think that's exactly right. That until there's been at least one review of that conviction, it's not a final conviction.
And I think I agree with that. I guess where I'm stumbling is this difference between dismissal versus vacating. I'm not sure that matters. Back to what Justice Lukert said, like it actually happened. It's not as though you're going to be Men in Black and erase everybody's memory about what happened.
If that's true, Then why not adopt vacator?
Because it doesn't make sense. It doesn't, in other words, what the remedy is just to dismiss it. Why would you go back and vacate some? There's no reason to vacate.
Yeah, I mean, even my colleague, I think, is admitting that, like, if there's a restitution judgment out there, that's still something that they think is enforceable or could make a difference in the world. I'm not sure if my colleague is admitting that anytime there's a restitution judgment, at least, a case isn't moot, even if the client dies. I'm not sure, but it would seem the logical conclusion. I mean, that conviction, here's the way to make sure that conviction has no further consequences. You vacate it.
Because there's an actual controversy existing though, right? Once the appeal continues. I mean, not every issue is moot once the appeal is started, right?
That's right.
Oh, okay.
Thank you for taking this case, Your Honor.
Thank you to both counsel for your arguments today. To say, I don't know that it's important, but we will take that matter under advisement, obviously. But I'll now call 125-455 State versus Matthew Munoz.
May it please the court, Patrick Dunn, Deputy Appellate Defender, here today on behalf of Matthew Munoz. And again, may I please have 3 minutes? I think to put it as concisely as possible, this case is simply a case of unclean hands. I think the relevant timeline is pretty clear in this case. Mr. Munoz was in the Mitchell County Jail while simultaneously being held on a pending DOC warrant for post-release violations. He sends a letter that to the district court, which gets filed on November 10th of 2020 in the middle of the pandemic, early in the pandemic, I guess you could say, saying, titled "A Motion for 180-Day Writ Callback," asking the court to begin the process to resolve his theft charges in McPherson County. Shortly thereafter, the then McPherson County attorney sends him a letter saying that he will be brought to dispose of that detainer after KDOC processes him. Then the following April, the state acknowledged the motion, files a motion for hearing. We have a first appearance on Zoom at the time. Mr. Munoz still in DOC. Then August 2nd of 2021 is a crucial deadline when this court reinstated the deadlines under the MDDA. And that was in 2021 PR 100. Then the final important date is April 11th of 2022 when he files his motion for continuance. After 252 days had elapsed. So we know at this point the state knew about the writ and it had sent Mr. Munoz a letter which any reasonable person would understand to mean that, yes, you've got this process that has begun.
Isn't the problem that your client never sent it to DOC?
Well,
And my follow-up is that uncontested?
first of all, there is no question that at the time that he sent the letter to the district court, the writ to the district court, that he did not notify DOC at that point in time. However, upon the state's questions during cross-examination, the state asked him, when you're in Mitchell County Jail, you didn't notify the Secretary of Corrections, is that right? And his response was, not when I was in the Mitchell County Jail, but when I got transferred, I did write your office. And I told the prison that I was on the writ or that I was trying to go on a writ. And I did keep everybody notified of everything every time I moved because I did move a lot, but I made sure I wrote every single time. And that was on volume 2, page 10. So it seems, yes, he did actually send notice to the Department of Corrections at some point in time. We don't know exactly when. And that was noticeably absent.
Is that a fact finding by the district court?
No, that was not in the district court's fact finding.
Fact finding was that he did not give notice to DOC, correct?
I don't know that it was that he did not, but he certainly did not at the time that he filed his motion, his writ. And we don't dispute that at all. We would contend, however, that it's that absent from prior proceedings was apparently no one had noticed this, that during the state's cross, that yeah, there was actual evidence that he did do it at some point, which should have triggered DOC to send those certifications.
And am I correct that
Which brings us into Griffin.
Your primary argument, as I take it at least, is, look, he may not have notified DOC, but that doesn't matter in this case because he clearly did notify other agents of the state. And that's enough.
No, that's
Okay.
not enough. What makes the difference in this case is the concept of unclean hands. If he had just notified everyone, that's not enough. However, at the Griffin court, in Griffin, this court recognized that latches can still apply. And in Griffin, it was a situation where there was a 2-week break in between the time when Mr. Griffin sent his motion to the district court and the time, and he also notified DOC. DOC didn't send that certification for 2 weeks. However, that apparently he should have waited 2 more weeks before he filed his motion to dismiss because that 2 weeks mattered in the timing of the 180 days. But in Griffin, this court said latches still applies. If DOC doesn't do what it's supposed to do in a reasonable amount of time, then latches would still apply.
Right. What's the unclean hands here?
There is no reason that the concept of unclean hands shouldn't apply to the state. When the state leads someone to believe that they have properly invoked the
So you're talking,
MDDA
you're
procedure.
talking about the correspondence back from the county attorney to your client.
Correct. If that had not existed, we'd be in a different case altogether.
So, okay, so I want to direct your attention to the statement in Griffin when we said, quote, when the inmate does what the UMDDA requires, statutory compliance may be excused. This is your notion of unclean hands. But it strikes me that that sentence, at least what I just read, suggests that compliance with the statute comes first. In other words, or I should say, the inmate's compliance. When the inmate does what the statute requires.
And he had begun to do what the statute requires. The statute has multiple.
Right. It addresses obligations to both defendants and state officials.
Correct. And he had begun to undertake those obligations.
But I thought you just admitted to me that he did not fulfill one of the crucial obligations.
One of the
which is to
obligations.
Notify DOC.
Correct. And I'm acknowledging that. But the problem here is that the state led him to believe that he'd done everything correctly.
This is not a substantial compliance case. In other words, you're suggesting that just the equitable doctrine of unclean hands can apply in
We're saying-
general based on the letter that was received back, which therefore then prevented or deterred him from taking further action to comply with the statute.
We think unclean hands extends substantial compliance to taking any action under it. You don't have to get to the point of, in Griffin, it appears that the court kind of sets a bright line of, okay, the statute says you got to have this certifications when it starts the clock. That's what Griffin says. But this is a different situation than Griffin altogether. Because he initiated those proceedings. He began his compliance. And that was short-circuited. Had the state not said anything, we'd be in a very different situation too. Because under Griffin, he has this obligation to check to be sure things are going. going okay, is the way I read Griffin. But that changes when the state affirmatively leads him to believe that he has taken the action that he needs. What else are you supposed to believe when the county attorney says, okay, we've gotten your motion, your writ, and we are going to bring you back to undertake proceedings in this case. You'll be brought back after your process by DOC. No reasonable person would not interpret that. Or I guess that's too many double negatives. Any reasonable person would interpret, all reasonable people would interpret that to mean you've done everything correctly and the MDDA is underway. The 180-day clock is ticking. That's the problem, is he was misled by the state.
Is it mislead, is it that he was misled, or is it, and there may be no distinction here, but my question is it that he's misled, or that he just got a pro forma letter from the county attorney that they always send because they assume that the defendant would have followed the statutory requirements?
I don't see how it's pro forma when he says after your process by DOC.
I'm just
This was a
saying,
unique situation in as much as he was in the Mitchell County Jail under a DOC warrant based on his post-release violations, which I assume were premised upon both the McPherson County allegations and the Mitchell County allegations. So that wasn't a form letter he was sent. And unfortunately, we don't have that in the record, but we're talking, that's the state's job at that point, because the state was the one who lost this. Their job was to ensure that the record proves otherwise. We have to assume the district court made appropriate findings below. Clearly, the district court took this into account. The district court statement was, yeah, because the state tried to claim, oh, we didn't know what was going on with this. We didn't know it was we didn't know it was the MDDA. And the district court said, no, you did know in its order. It was clear. They didn't believe this. They didn't buy what the state was selling on that. And
Wait, when's the clock run then, under this unclean hands theory?
frankly, it should be at the time when the unclean hands take place. That's the obvious time for it to take place, which in this case doesn't matter because the real clock doesn't start because everything was suspended at that point in time. This is an easy case because the clock starts August 2nd, a year later, and the 252 days had passed after that point in time, well after the unclean hands took place.
How is that fair to DOC? I mean, it may not be okay with them that some county attorney is speaking for them.
It's
They have
unclear to me,
obli-
it's
because
unclear to
they
me
have
what
to-
DOC's, I'm
Well,
sorry.
because they have duties here too. DOC has to, has certain obligations under the, MD.
DOC's obligations are ministerial. They don't have an interest in this. DOC's duties are to say how long the sentence is, what other cases you have pending, and how much good time you have, and then to send that on to district attorney. The district attorney is the one, if anyone, who would be quote unquote harmed or have an interest in this, because they could choose, well, we want to rush this and get this taken care of or not, because he has these other pending cases out there, or we need to take care of this sooner rather than later, because under the changes of the MDDA in 2016, now it's clarified that if another case is picked up on a detainer action, then that doesn't keep the clock running in all the cases. All the cases don't run on 100 simultaneously on 180. But the point being, DOC doesn't have an interest in this. DOC's job is purely ministerial to provide information to the state.
But
They
what-
have no interest.
But what they do starts the clock, right?
What they do does start the clock, but the clock matters not to DOC, but to the state. And the state is the one that's obliged to follow the clock. And when the state leads someone to believe you've done things and the clock has started, they can't pull a bait and switch and then later say, oh, no, you didn't do it right.
Well,
That is fundamentally unfair. That's what unclean hands is all about. They weren't prejudiced by this in any way, shape, or form. The only person who was prejudiced, if anything, was Mr. Munoz.
earlier, though, you cited to the record that he later did notify DOC. Does that suggest that he did not then in fact rely on the letter he received from the prosecution? Why would, I mean, if his, it didn't induce him to sit on his hands.
No, presumably the reason he was notifying them was so they would know, hey, I'm going to be getting brought back to McPherson soon to resolve this. That's why I would interpret that. Not, I need to do more about this, but I'm going to get brought. be sure anything coming from McPherson County comes to me.
One
That's how I logically interpret that. Again, one thing I did want to touch on was, the Court of Appeals, that it was unclear when he, exactly was served with the DOC warrant. And I briefly wanted to touch on that because that should have never been reached, discussed, or talked by the Court of Appeals. The question of when Mr. Munoz testified in the record that I was in at the same time on the DOC warrant and the Mitchell County charges. That right there is substantial competent evidence that he was under a DOC warrant at the time. Now,
Did he ever receive the warrant? Or does that?
he said he was under the warrant at the time. That's evidence right there that he did. If the state has a problem with this, you know when the time to bring this up was in the district court, because frequently, I don't know how many times we are told on appeal, you can't raise factual issues for the first time on appeal. And that's a simple question of fairness, because if there was a factual question, that should be raised in the district court because it can be addressed with more evidence at that point in time. If the state had a question as to when it happened, it should have raised that in the district court because this could easily be resolved. There was talk of Casper earlier. Guess what? If you look at Casper, that DOC warrant was issued in August of 2020, 3 months before this. So clearly that DOC warrant existed. Now, I understand that's not part of the record, but you know what? It could have been brought in the record had the state raised this at the district court level, which is why it is improper to raise it on appeal for the first time.
Anyone seen the warrant? Actual warrant?
Has anyone seen?
Well, yeah, was it ever produced?
I don't believe it came in below.
It's just been testimony about the warrant. but its
Testimony
actual
is
production has never been had.
correct. Testimony is evidence, however,
No,
and
I
that's,
understand.
we're only looking at this
No, I-
point
I
at substantial
understand.
competent evidence.
I understand.
If the state had a quibble with it, the time to do that is not on appeal for the first time. Factual issues are resolved in the district court, not for the first time on appeal, which is exactly what the Court of Appeals did in this case, was said, we want to find out about this evidence for the first time on an appeal. Everyone proceeded below. No one ever said, and it was even pointed out during the argument in the closing argument by defense counsel, that the states never objected to any of this until, had never objected to the timing of anything. So given that that was the time to do it, it should never have been brought up now. There was substantial competent evidence based upon his simple testimony. That was the only other thing I wanted to be sure I touched upon. I'm going to try and let everyone get to a reasonable lunch hour at this point. Well, I can't promise anything on rebuttal. So if there's no other questions, let Mr. Obermeyer say.
May it please the court, the state appears by Stephen Obermeyer, Assistant Solicitor General. I've tried to get Mr. Skeens with Blue Valley to stay to hear this argument. Had to go to see the legislature. I would like to address what was actually raised in the district court at the hearing on the motion to dismiss. And that was defense counsel citing an obsolete version of the MDDA statute, which stating the duty is on the jail officials to send the notice to McPherson County, to send a certificate to McPherson County. And it was argued several times, and it's in the state's brief of appellant, all the defendants saying that it was Mitchell County's job to notify McPherson County and do the certificate. That was the argument to the district court. And so on appeal, I write a brief saying the defendant was not in custody of the Secretary of Corrections. The statute doesn't even apply. The statute was amended substantially since the volume 2A. And so now my colleagues are arguing, oh, King's X, he was in custody of the Department of Corrections. That's why it wasn't considered, because it wasn't raised by the defendant in the district court. His argument was it was the jail's obligation to issue the certificate. And that's why I had argued that he should be judicially stopped from talking out of both sides of his mouth by arguing to the district court that the Mitchell County Jail's job was to issue the certificate. And now on appeals, like, well, you know, the state didn't produce this, we don't know when he was arrested on the warrant. So now so he was in custody.
Is it your argument that the district court never actually made a fact finding on the custody question?
As far as DOC custody, yes. The district court never said that the defendant was in this custody of the Secretary of Corrections, the Department of Corrections at the time that was filed. The court just ruled that there was no action taken by KDOC, the Secretary, or otherwise being the jail officials of Mitchell County. They didn't do anything, and that's why the case gets dismissed. And now we're arguing that, oh yeah, he was in custody, and being a detainer, he was in custody in Mitchell County for I think it was a theft case from August to December when he was sentenced. At the time he filed his motion 180 writ callback, and I could do a Seinfeld bit about what is this? Is it a motion? Is it a writ? But by the time he filed this, his case was still pending in Mitchell County. He had not been sentenced yet. So McPherson County can't drive out there, you know, we're here to get Matthew Munoz, take him to McPherson County. His case is still pending. What's going to happen at the sentencing date in Mitchell County? When he's not there, he's in McPherson County because he filed this, which mentions nothing about the MDDA, mentions nothing about final disposition and detainer. He just wants to begin the court process. If this case would be an example, what's the minimum I could put in something and have it qualify as an MDDA motion? This doesn't do it, and that was one argument the Court of Appeals did not consider, and I asked this court to consider. I cited a Colorado case, I think State versus Campbell, where you don't even mention the MDDA or final disposition or anything like that. And because when in 2016, when the legislature amended the MDDA, it put a trigger on when the prosecutor can worry about when the time starts to run. And that is when a person or any inmate in the custody of the Secretary of Corrections files a request for final disposition and gives notice of it to the county attorney charged and to the Secretary of Corrections, which was not done in this case as well. And so when the certificate does come from the Secretary of Corrections, then the prosecutor knows, okay, the time is running. And the prosecutor doesn't have to rely on every random jail mail that's received. And as far as what's the legal significance of this? Certainly the defendant wanted to begin the court process. This is a far cry from saying he was invoking the Mandatory Disposition of Detainer Act in doing so. In Ekus versus Dar, the defendant wasn't even aware that there was such a thing. I think.
Let's take a step back. Okay, the reason under the MDDA after 2016, the reason you send it to KDOC, okay, so the prosecutor doesn't have to worry about every allegation or whatever.
Right.
The reason you send it to the KDOC is so they can certify, okay, this guy's under KDOC custody. So they certify that, and then they send it to the county attorney.
Yes.
Okay. And the reason just like you just said, that's so the county attorney is made aware the clock is ticking. Okay. And that's the purpose, right?
Yes, they can decide whether they want to, what kind of sentence is he serving? Is it worth bringing him to McPherson County on this theft case?
But that happened here, right? The county attorney was like, okay, we know. We're on notice.
We're on notice.
And here we're sending you a letter saying, okay, we're aware and we've made our plan. Our plan is as soon as you, you know, get convicted or whatever and actually get transferred to a facility that is run by KDOC, even though you're being held, you know, then we'll do it then. So the whole purpose of the statute was satisfied, right?
Justice Standridge, I don't think that, I think wanting to be brought back for trial, which the prosecutor said, we'll bring you back, and wanting to be brought back for trial under the MDDA are two different things. And not every, you know, request to be brought back means it's under the act. And the statute was amended to require notice to the Secretary of Corrections so they can calculate this. And the certificate is what triggers the prosecution or the prosecutor to decide whether to bring them back. And by the way, he was brought back the day after this court set aside COVID in August of 2021. He has a prelim in August of 2021. He's got a pretrial in November of 2021. Says nothing about, hey, what about my mandatory disposition of detainer, especially when it gets set beyond his perceived 180 days. The court's going through an analysis as far as speedy trial under the speedy trial statute, as far as setting it for trial. So he can just say nothing about it until.
You could argue the reason that they brought him back the day after was because they were aware.
Well, because they were aware of the MDDA.
Yeah.
I don't, you know, think the prosecutor has to do a mind meld of Matthew Munoz and see what his
Well,
intent
the
was.
prosecutor knew, right?
He wanted to be brought back.
Well, I
Yes.
don't really think that the defendant would have an obligation to tell the court and the state that the clock is ticking against the state. But my question is, do you agree with Mr. Dunn that the DOC really doesn't have a dog in this fight and they don't really care whether the county attorney speaks for them?
I would think the DOC would not want the county attorney speaking for them, that there's a case on acquiescence. The state can't acquiesce or confer jurisdiction on the case. It's the DOC that prepares the time served, time remaining, good time credit, and issues the certificate. So I think that's more than a ministerial role, that you're putting the prosecution on notice that there's a request for disposition of detainer under the act. Not just that he wants to be brought back, but under the mandatory disposition of detainer act. So I think it is more than just a ministerial role, and the prosecutor can't waive that or acquiesce. The parties can't confer jurisdiction to say that the act.
So does you agree that DOC has independent duties under the MDDA?
Yes, and it's set out in 4302 as far as what they have to do, and they were not notified of this, and so that's why we're even at the unclean hands argument. And I did cite some cases on unclean hands, and it involves something, you know, inequitable conduct by one party, and I don't think, here it is. A litigant may be denied relief by a court of equity on the ground his conduct has been inequitable, unfair, and dishonest, or fraudulent and deceitful as to the controversy and issue. And that's Gobin versus Berry. The district court never found that the county attorney Benefiel engaged in any wrongdoing or inequitable or unfair or dishonest, fraudulent, deceitful misconduct. The letter did not say that the county attorney's office intuited that Munoz was aware of the act, opined that he was trying to invoke the act, and affirmed he had complied with the act's requirements. It merely said, this has been filed and you'd be brought back.
And we've applied equity principles in this context, but it seems to me it's been where there's been substantial compliance with the act, but due to no fault of the defendant, there were delays created by third parties. Here, it's a different situation. Seems like we're expanding it to excuse substantial compliance with the statute. And what's the distinction? And what would prevent us from going to making that next leap, I guess?
Well, I think the Griffin case says that it's more than, without clear proof of wrongdoing by the officials, the inmate has not effectively shifted the burden. And Griffin says that you at first have to comply with the act before we're going to start assessing blame as to whose fault it is. And the language in Griffin, we're talking about officials. I think we're talking about prison officials, the Department of Corrections, not the prosecutors for sending a letter saying we got your writ. So I think Griffin is the most recent pronouncement on what must be done under the act. And it was certainly after the legislative amendments in 2016. The defendant has to inform the secretary, and the secretary never sent registered certified mail along with the certificate to the court and county attorney, which starts everything. And there was no clear proof of wrongdoing in this case. And I don't think you should change what Griffin requires as far as misconduct or unclean hands or whatever you want to call that.
Counsel, can I take you back real quick to your judicial estoppel argument?
Sure.
Earlier on in your argument, we had a short discussion about whether there was a fact finding below. And I went ahead and looked, and at least as I read the record, it looks to me like the district court did make a fact finding that Mr. Munoz was in KDOC custody. Does that change your approach to the judicial estoppel argument?
No. And if you're citing volume 2, page 23.
Yeah, that's what I'm looking at.
Okay. The court says the state knew that actual notice of Mr. Munoz's intent to dispose of this detainer while he was in KDOC custody, and therefore this filed under substantial compliance with actual notice to the state. I don't know if that's a reference to the prosecutor's letter or the fact that when he's in KDOC custody, that he would have to notify them. Let's see, intent to dispose of this detainer while he was in KDOC. I don't think that's a finding that he was in KDOC custody because in the cases I cited, I think in this reply to the petition for review, you can't, if there's a detainer on you, you can't be arrested on the detainer. It's just
right. But the defendant's whole argument at the hearing, and he testified to this, is that he was under a warrant.
Well,
the evidence was there, even though the warrant wasn't.
I disagree with that, Justice Deagle. As to a KDOC warrant, he testified, he was asked a question like, when was the KDOC warrant served on you? And his answer was, I filed the writ when McPherson County sent me the warrant. It was a non sequitur as far as that. And that's what the Court of Appeals pointed out in the opinion.
You may be right on the merits of the evidence. I'm just trying to work through this whole estoppel argument.
Right.
And it strikes me that if a party below, through faulty legal argument, makes it so that district court doesn't make a fact finding that's necessary, judicial estoppel would suggest you can't turn around on appeal and blame the lower court. It's almost like invited error. It's a similar kind of concept. But here, I just don't see how you can make that claim when arguably, at least, the district court does make the fact finding. How are they stopped from arguing against a finding that the district court actually made?
Well, there was no evidence that he was in KDOC.
I know that's on the merits. Like the evidentiary question's on the merits. I'm focused on the estoppel part of it.
In the next paragraph, the judge says there was no action by the KDOC, the secretary, or otherwise or the state reaching out. I think that, or otherwise language is the judge saying Mitchell County was responsible, as the defendant had argued to him, that Mitchell County was supposed to do the certificate because that's the way it could have been interpreted prior to the 2016 amendments. But there was no evidence of that. And State v. Nicholson, and it's in, I think, the reply to a petition for review, says a person already in custody cannot be arrested on an outstanding warrant from another county or jurisdiction. Because it gets to, hey, we're, can McPherson County or KDOC say, hey, we're here to arrest your guy from the Mitchell, from the, what county is he in?
McPherson?
Well, McPherson going to Mitchell County, we're here to arrest him, to, take him to trial. And KDOC can't say, we're here to arrest him on our detainer. A detainer is just, let us know when he gets out, when he finishes, because we've got dibs on him or we want to consider whether to bring him back. That's way different from saying that he's in custody on the KDOC warrant, or that he's in custody on the warrant from McPherson County. A person already in custody cannot be arrested on an outstanding warrant from another county or jurisdiction.
Well, this was a probation violation, right?
No, this was a theft charge that was filed, I think in September of 2020. And by the way, the hearing on the motion to dismiss was in July of 2022. There's, a 2 or 5 year statute of limitation in criminal cases. This was all considered and done before that had even run. So it was pretty fast, especially once the once this court issued the order that we're resuming trials. So I see that I'm out of time, but I would refer the court to the last couple of pages of your opinion in Griffin, as far as the duties on the defendant, what the defendant has to do before it even triggers, what the Department of Corrections has to do. And this was not misconduct by the prosecutor sending a letter advising that it had been filed. And I don't think Mr. Munoz should be rewarded for misarguing that the MDDA applied to the Mitchell County Jail. So I think I agree with what the Court of Appeals put in its decision, and would ask you to affirm that. Thank you.
Frankly, I don't think the state should get to benefit from misleading clients. I think that's where the real problem is here. First, I wanted to turn quickly to the judicial estoppel. And I fully agree, there was nothing inconsistent here. We had factual finding. He even pointed out in his motion to dismiss that he was being held on a detainer at the Department of Corrections. The state somehow is trying to make an argument that a detainer is not the same as custody. Burnett, I think, says otherwise. Burnett says custody contemplates an intent on the part of prisoners officials to exercise actual constructive control of the prisoner, and that in some manner the prisoner's liberty is restrained. I think that falls squarely under. But even more importantly, if we go back to speedy trial cases, and we know from regular statutory speedy trial that if you are in custody on something other than the pending cases you're arguing speedy trial in, then that speedy trial doesn't apply. Yet in State v. Hill, 257 Can 774, this court said, well, he had a DOC detainer, so he wasn't in custody solely on the pending charges. So this court has recognized that DOC warrants constitute custody. So there is no real argument here that it's not a real thing.
So I want to shift you to what I take to be your primary argument on unclean hands in the time you have left. And I want to hear your best argument. And I'm going to quote here from the language this court has used in Sweat and Griffin. What's your best argument that the letter from the county attorney was, quote, affirmative wrongdoing intended to thwart the inmate's request by misfeasance or malfeasance?
when let's just make it even simpler. If the letter had said, we know from the district court's factual finding that the district court found, we can't do the state's Key Rock, SNL, Phil Hartman. We didn't know what this was. Your ways confuse me. District court found that they knew this motion for a writ was an attempt to invoke the MDDA. So given that, if we can make it simple, the letter says, we have received your motion to resolve your pending detainer in McPherson County per KSA 224301 et sec. We have received this and are proceeding accordingly. You will be brought to for further proceedings under KSA 224301 et sec following your processing with the Kansas Department of Corrections.
How is that affirmative wrongdoing intended to thwart the inmate's request?
Because the inmate requested to be, what is the inmate's request under the MDDA? The inmate's request is, I want to be tried within 180 days. That's what the
So this letter
MDDA is.
in the county attorney's head, I mean, what you're alleging is that the county attorney essentially wrote this letter as an affirmative attempt to undermine this request.
That's exactly what I'm saying. Otherwise, we have to take effect to it. The state can't sandbag this sort of thing and say, oh, no, it's not now. That is really, it thwarts the entire purpose of the MDDA, which is to have a resolution of these pending charges so that there's no uncertainty out there. That absolutely thwarts it. If the state can send a letter like this to, what if that is the case, why would the state not in every case send out that letter?
Well, I was suggesting they probably do, because if in fact the inmate had complied with his statutory obligations, there would be nothing at all wrong with this letter.
The problem is that this letter misleads a defendant into
And I
believing
wanted
they
to-
did.
I wanted to grant that, but I think that the legal standard for unclean hands is higher than a simple misleading or misunderstanding. And again, that's why I just wanted to hear your best argument for how this is an affirmative wrongdoing that intentionally thwarts the inmate's request.
I think that if upon that, well, if we want to move further along to the actions of the subsequent county attorney, which clearly took place sometime after January 3rd of 2022. And I know this, we can say this because the final journal entry submitted by Mr. Benefiel was, I believe, of a pretrial hearing that was filed on January 3rd. Subsequently, we have an acting county attorney, and then we have the attorney who handled this, Mr. Perkins, filing everything. If at that point they believed something was wrong, then they had a duty to remediate what the affirmative misleading was before. That certainly is unclean hands at that point too, if they believed otherwise, because they knew he wanted to get this done as quickly as possible.
Essentially, you're suggesting that letter can't go out until really the certification is received back from DOC.
Yeah, if you truly believe, it ought to mean what it says. You ought to be able to rely on it. I think that is what latches and unclean hands are all about. You can't mislead someone like that to their detriment. And there's no question he would be prejudiced, because the Court of Appeals found there was certainly, that if we reverse this, that certainly prejudices him. And the final thing I wanted to touch on was, again, Mr. Obermeyer and Your Honor, turning back to 4302, of course, the state was claiming that, no, it's not ministerial at all. The actions required under 224302 are to certify the term of commitment, time already served, time remaining to be served, good time earned, time parole eligibility, and any parole board things. Certify any good time for crimes after any guideline sentences. And finally, to send via registered or certified mail, a copy of the request and certificate to the county attorney. That is literally ministerial. Now, what interest could the DOC possibly have? Under Griffin, they have to promptly do this. They don't get to decide, we're going to put this off, are we going to do it? Are we not going to do it? There is no, this is like a computer program. It is as definitionally, literally ministerial as it comes. It is purely a ministerial act. So they don't have an interest. They are DOC is in no way harmed. The only party at issue is the state. And the district court found the state was fully aware of what was going on. That was a factual finding made below. Finally,
You don't think that DOC is going to be blamed privately and maybe publicly if they don't do that certification in a timely manner?
well, if they don't do it in a timely manner, then the defendant wins under
Does-
Griffin.
Right,
That's
doesn't
what we
that
say
give them
there.
a due process right to be notified?
I'm sorry.
Doesn't that give them?
They don't
the-
get a right to be.
Well, they are supposed to be notified under the statute. That's what triggers their obligation to do a certificate.
Certainly. In this situation, they have no obligations. There is no harm to DOC here. To be a party with an interest, there has to be some kind of harm that could come to you or some kind of benefit. There is no harm or benefit in this situation to DOC. So therefore, they're not really a party of interest. They are purely ministerial. That's where certainly the county attorney might try and blame it on them later because they're a political actor and they're elected and they want to win their election and they want to deflect on why they misled, why a case might have been reversed because they took actions that misled a defendant. Sure, they might want to blame somebody for that, but that's a political question there. That doesn't have to do with legally whether it's ministerial or not.
Well, there's no allegation that they received notice, is there? There's no evidence that they received notice.
Well, there was, again, I point out there wasn't a finding on that, but there was evidence in the record. And in as much as in response to the county attorney's questions on cross-examination, he informed the Department of Corrections that he had filed or was attempting to get filed
Right, but there was no.
under the MD. He did not produce there was not paper documentation on that, but there was testimony on that. And that was in direct response to the state's cross-examination.
Okay, just to clarify, there was evidence, but no finding.
Yeah, there was no finding on that. I will fully concede there was no finding on that because no one took that at issue. District court proceeded as though it wasn't. But again, I don't think that's, I think we're still, ultimately it comes down, this case is an unclean hands case. I think that's what this whole case hinges on. And again, we don't think the state should be rewarded for misleading defendants when it directly thwarts the purpose of the MDTA. No further questions. I would ask that this court affirm the district court and reverse the Court of Appeals.
To both parties for your arguments today. The court will take this matter under advisement. The court is now in recess until 9 a.m.